He was convicted of brutally killing his wife with a corn rake. But to this day, this Iowa farmer says he's innocent.
I did not do this.
Now Todd Mullis is fighting for freedom, making his last-ditch effort to get a new trial to prove he wasn't the one behind the horrifying homicide on his family's pig farm. This is On the Case, presented by Law&Crime. I'm Chris Stewart. Today, Todd Mullis was back in court as his high-profile murder case is back in the spotlight and in front of a judge, this time for a civil bench trial. Now, before we get into the unique proceedings that kicked off this week, let me remind you of how this story played out starting in 2018 with this 911 call in Delaware County, Iowa.
Delaware County 911, what's the address of your emergency?
Oh, this is Todd.
Hello? Where are you at?
I'm on the road. I'm out of breath.
Okay. What's going on, sir?
My wife, what the hell? She found a full pork sitting in the barn.
Okay.
And she's not responsive. I'm just, me and my son bring it.
Okay, so your wife is in a barn. You said she's unresponsive?
No, she was an old what do you call corn fork.
Okay.
I don't know if she tripped. I don't know. She was halfway out the door. I sent my son over to check on her.
Okay.
She yelled at me, and I'm on my ride.
Okay.
She looks gone.
Okay. We'll get an ambulance going in just a second.
I'm headed there. I'm about to.
Okay, so you're headed to where? Okay, what's
the hospital?
You're.
I just grabbed her and I threw her in the truck.
So
when my son called me.
Okay, you're headed to the hospital, and she's in your vehicle.
Yes, my white truck.
Okay, just a second here. Is she?
There's no Paul.
There's no Paul. Can you just get on this one for me? Just a second. I'm gonna have another dispatcher get on. I'm gonna ask you to can you pull over?
I can.
Okay. How about you pull over?
Sir, what's your current location, and we'll get an ambulance headed your way.
Orida.
That is farmer Todd Mullis, who called 911 saying his wife had been found with a corn rake sticking out of her back. Now, if you're not much of the farming type, this is a corn rake. In fact, the exact rake was presented as evidence in the trial. Todd told investigators that he, his wife Amy, and their 13-year-old son Tristan were doing work on their pig farm. And that's when Tristan found his mom with a rake sticking out of her back. Todd told investigators that Amy must have fallen on that rake. He tried to drive her to the hospital, but she died. Investigators grew unsure of the accident theory that was presented by Todd, partly because Amy had 6 puncture wounds in her back, and a corn rake has 4 prongs. That means the rake had to come out of her body, then be stabbed back in. Investigators didn't just look away from that accident theory. They looked directly at Todd as a suspect. He was arrested a couple months later in February 2019 and charged with Amy's murder and put on trial.
Amy Mullis didn't stand a chance. She was unarmed and unaware that she was about to be ambushed by the very man that took a vow to love and honor her, the defendant. Amy Mullis would still be alive today if it weren't for the actions of her husband. She started that day like any other day, working on a puzzle, making breakfast for her family, and doing some chores on the farm. She didn't know that was the day that the defendant was going to seize his opportunity. He was going to attack her in the back with a corn rake and try to make it look like an accident.
In his criminal murder trial, prosecutors presented evidence and argued Todd was fueled by anger, that Amy had an affair roughly 5 years prior to her death, and he had also recently discovered internet searches to suggest she was having another affair with a farm manager named Jerry. Todd took the stand in his own defense, and the prosecution presented internet searches they said he made, arguing he had a motive for murder.
When do you suspect Amy's having an affair with Jerry? Or you're worried about their relationship being more than just business?
When I thought it was odd about Jerry was mid-July.
Okay. Now, you've heard testimony from Jerry that he did have an affair with Amy.
Yes.
And you were probably pretty shocked to hear that when you heard about that, eventually.
Yes.
And you heard testimony that that affair started in May 2018, right?
That's what I heard.
That's what you heard.
He said June, so.
And on May 10th, 2018, there's a search for what happens to cheaters in history. Did you do that search?
No.
How about the search right after that? Once a cheater, always a cheater. Did you do that search?
No.
And right after that, typed in what happened to cheating spouses in historic Aztec tribe. Do you remember that one?
No.
And right after that, killing unfaithful women. Did you do that search?
No.
And the last one of that bunch is a visited site. Punishment is 18 months for killing cheating wife. Did you do that one?
No.
Do you know who did it?
No.
Todd's alibi had been that he'd been with his son the entire time, and that is what the young teen told investigators. But then over time, that story started to change. Tristan then testified in court there were times that he lost sight of his dad before he discovered his mom with that corn rake sticking out of her back.
Todd, I'd like to then move forward to approximately 4 to 5 years ago in time. And we've heard a lot of testimony about Amy having an affair. You recall that?
Yes.
And was she working at the Manchester Hospital when that happened?
Yes, she was.
And we heard Terry Stainer talk about her and Amy were good friends at that time.
Trying to think, what year was that now?
When this first affair occurred.
Yes.
Okay. And after you learned of that situation, what did you and Amy do about it?
Well, basically after we, I discovered it, we decided, immediately that she wanted to make it, quit her affair, go to counseling.
Another key piece of evidence against Todd was this pet carrier. Amy had just had surgery and she was struggling physically to do farm work as she recovered. And a key part of the narrative of that day was that Todd asked Amy, as they were working, to go get that pet carrier. Todd argued, as they worked on the farm, that she was willing to help, and he encouraged her to step away and go rest.
Was there any further concern about how Amy was doing?
Yes, it, not every pen, but every so often she would get down and it would take her longer to readjust, and she said she was just dizzy. She kept getting dizzy. So we just kept asking her if she was okay. Sure you want to go back in the house? And she goes, no, I'll just keep going. It ain't that bad.
That she indicated that she wanted to be helpful.
Yes, she didn't want to go back in. She didn't want to feel worthless, I guess.
And in good health, this would certainly be something that Amy would be engaged in fully.
Yes, it would be no problem.
Okay. At some point, did she concede and agree to leave the hog barn?
Yes, after multiple times of asking her if she was okay. We were concerned about her, both Tristan and I were concerned about her, and we kind of go, hey, I think, you're going to get too hurt here, you're going to fall off, so why don't you just go in the house?
And she agreed.
Yes, reluctantly, yes.
But prosecutors found it odd that Todd would ask Amy to go lift something heavy when it was clear she wasn't in great shape after surgery. Another controversial piece of evidence from the original trial was the 911 call that Todd made as he rushed his wife to the hospital. Dispatchers asked Todd to do CPR. Let's pause right here because this is a very important part of this trial, because prosecutors were able to present to the jury that they heard Todd calling his wife a cheater in between chest compressions. But when you hear that tape, what do you hear? There's a lot that is up for debate. But again, it was allowed to be presented to the jury during the trial. In September 2019, the jury deliberated for 7 hours and then returned the verdict.
We, the jury, find the defendant, Todd Michael Mullis, guilty of the crime of murder in the first degree.
Mullis was sentenced in 2020 to life in prison, but he continues to declare his innocence.
I did not do this. This is supposed to be America where you have a fair chance of proving your innocence. But you shouldn't have to prove your innocence. Instead of the other way around, I thought it was guilty until, or innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband, and I never did this.
Through the appeals process, Mullis has raised questions about the investigation and even his own representation in his first criminal trial, especially with what his own defense argued. Listen to what his attorney said in 2019 to the jury.
So they did their jobs, they explained things to you. Amy was murdered. Dr. Thompson figured out that it wasn't an accident. He found more holes, and then they started to investigate, more puncture wounds. The state goes through, and I'm just too old to try to learn it. I don't have a PowerPoint, so just please listen to me as closely as you can. Those elements of malice aforethought and all of those things, you only have to get there if you think Todd did anything. Those are complicated instructions, and they have all this terminology. If you don't think Todd Mullis committed this act, then you don't have to try to analyze all that stuff.
Mullis now says he never agreed to admit that Amy was murdered and not the victim of a farming accident. Here's what his new attorney argued before he was sentenced to life in prison.
During the course of cross-examining Mr. Mullis, so these questions were not asked by his lawyer, they were asked by the lawyer for the other side. So during cross-examination, back July 7th of 2020, the question was asked by Mr. Strong of Mr. Mullis. And I quote, "And I believe during your criminal trial, you took the position that Amy was murdered, but it just wasn't you. Do you recall that?" Mr. Mullis, under oath, says, "I never said that." The next question. "Well, I believe that was evidence that your attorney asked you during the criminal trial. You don't recall that testimony." There's an objection, and the question gets reread, and Mr. Mullis answers, "I never gave my lawyer the request to state that." Meaning, I never asked my lawyer to concede that this was a murder and just take one of the elements that the government would have to prove beyond a reasonable doubt out of the equation.
Mullis's appeal of his conviction in 2022 was denied, but his efforts to overturn that guilty verdict weren't over. Mullis has received a ton of support since his conviction. FreeToddMullis.com is a website with a petition raising money for his defense. It's sponsored by a legal nonprofit that was founded by one of his attorneys. In 2023, Mullis filed an application for what's called post-conviction relief. In Iowa, you can challenge a conviction for reasons like you have new evidence, had ineffective counsel, or believe your conviction was unconstitutional. Now, typically, these efforts play out when a defendant has exhausted options through the typical appeal process. What we're watching play out right now is in civil court. And that leads us to today, the start of what is expected to be a 10-day hearing in civil court where a judge will determine whether Mullis can get a new trial. 40 witnesses are expected to be called to testify. Here's what his attorney said today in her opening statement with Mullis sitting by her side.
The court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Ms. Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Ms. Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history. Those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week, and present them in a public way that Ms. Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved. But that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice. And that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Then the state of Iowa had an opportunity to respond, and this is what they said in their opening.
As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding, which Mr. Mullis has brought and commenced to attack his conviction again. The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis's murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many, many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach or a shot in the dark, in a way, is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial and what has already been upheld on appeal. And that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already, and find that his conviction of first-degree murder should stand. Thank you.
Thank you, counsel.
Joining us now to talk more about what we could see and how we got to this point is criminal defense attorney Andrew Baldwin. Thank you for taking the time to be with us today. First off, this civil bench trial that's taking out, how common is it to have a process like this play out that could potentially lead to a new trial?
Oh, it's the last resort, Chris, for any defendant that has exhausted all their appellate processes that are out there. This is so throughout every state, it's very, very common to get to this point in terms of asking for the hearing. Now, what's a little bit more unusual or a lot more unusual is actually getting the hearing. And most, maybe 99 out of 100 times, the judge just denies these things without a hearing. Often, if they do have a hearing, it's pretty rare.
What does it tell you about this case that it was actually granted, that they now are going to have this 10-day hearing with 40 witnesses expected to testify?
Well, it means that the judge, it may mean at least that the judge thinks there's actually something there and that it's worth looking into. Because especially most PCR hearings is what we call it, post-conviction relief hearings. They last, maybe an hour, maybe 2 hours. But when it's 10 days, I've never seen anything that long before. So that's a lot of time to take out of a judge's calendar. And especially when it's being aired live and so forth, it might be a good sign for the defense that the judge thinks that something might be there worth looking into.
Let's dive into some of the parts of this case that have been up for debate. And one of the big ones, as Todd Mullis has said, the defense that he was given by his attorneys in his first trial was not what he wanted. His defense attorney said that Amy was murdered. And he says he never admitted that was the path that they were going to go, that he still believes that she was the victim of a farming accident. What do you make of that dynamic that he's argued now for a couple of years?
Yeah, it's difficult. People don't understand the shoes of a defense lawyer until they step into them. And there's some difficult decisions that need to be made as defense lawyers. It is, for the most part, you're on the same page with your client, but every once in a while, the client just wants it done a certain way. And you as a lawyer have to make a decision. What people don't know is the client does not get to make that decision about the strategy moving forward. The client gets to make a couple of decisions in the course of a case. Number one, do I take a plea? Number two, do I take the stand? And between those two things, the attorney doesn't have any ability to say no. However, when it comes to strategy, the lawyer, they have the full say. You want to try to get along with your client during the course of the case, but sometimes you have to go a different direction. It's pretty rare, but it does happen. And I think one of the problems I think going on in this particular case is on the opening statement that I watched for this PCR hearing that's going on right now. The prosecution said that on cross-examination during the actual trial back in whenever that was a few years ago, that the defendant Mullis actually said, I think this is murder on cross-examination. This is not an accident. And that could be problematic trying to explain that away, especially when he's under oath.
For you, if you were his counsel going back to the original trial and he said, I want to go with the farming accident defense, as opposed to saying that she was murdered, what would you have said in those conversations?
Well, my law firm would have probably gathered everybody, lawyers and staff and receptionists and everybody into a room and looked at the evidence and said, does this work? Which way does this play? Because we'd like to honor what the client wants, but if it's so far-fetched and ridiculous, then you don't want to do that. So you like to get all kinds of people and their opinions in play. One of the other things going on here that I thought was interesting when I was watching some of the original trial testimony is, I don't know if it was the coroner or the forensic pathologist, but somebody got on and they said, well, when it was explained to you that it could be a fall from a pitchfork, what was your thoughts? And he said, it didn't seem likely to me. Something along those lines. It was very non-committal versus what it could have been, which is, there's no way that was a fall onto a pitchfork, or there's no way it was an accident. And that makes me think that just that alone makes me think that there was some life to the accident theory, and maybe it should have been checked out. But again, I don't like playing Monday morning quarterback with lawyers. I don't like that when they do that to me. But, now that they lost, you probably ought to have gone with a different defense.
Because he loses or is found guilty in the original criminal trial, loses his appeal. How much, in listening to the opening statements today by his attorneys, it did sound some of the similar arguments that he's made since he was convicted, that he didn't have a chance to have the defense that he wanted and some of the other concerns that he had. In these type of hearings, I mean, how much more evidence do you need to bring to the table that is different than what you've said in the past if you've already exhausted all your other appeal processes?
You need to bring significant evidence, I think. I mean, one of the things that is interesting, I will applaud the trial lawyers for doing this. In fact, one of the pieces of evidence from my understanding is these lawyers that did the trial, they have conceded that they were ineffective, almost, that they should have looked into expert witnesses, that the expert witnesses, should they have looked into them, would tell a different story, that an accident was in play. And so that is one significant piece of evidence, is the trial lawyers falling on the sword, so to speak, and saying, yeah, we were ineffective. We should have done something different. But then you have to back that up with the evidence that they should have put in to play at the trial. And apparently that's going to happen here. And you better have some very good expert witnesses coming on and saying, yeah, this was definitively an accident, or could have very well been an accident, and that way the ineffective part of the claim becomes even more important.
I want to get your take on this infamous 911 phone call. And during the CPR compressions, the prosecution was able to tell the jury and confront him and say, did you call? And I can't really say it on air, but ultimately calling his wife a cheater under his breath as he was doing chest compressions. I've listened to that recording multiple times. I can't seem, and maybe for other people, they can hear it. I can't seem to hear it myself. What did you hear?
I didn't hear anything. It bothered me that the prosecutor was able to voice the words of what she thought that she heard. I don't know if there was a motion in limine preventing the prosecutor from putting that out there for the jury to hear, because sometimes once you hear something, then you cannot unhear it, and you start to think, that is that what they said? And I think in my opinion, it's inappropriate for the prosecutor to put that out there. It should have just been, what did you say here? And he says nothing. And then on closing arguments, the prosecutor then can say, here's what I hear. And I thought that was inappropriate for the prosecutor to have done that, unless it was ruled upon by the judge pre-trial. But I didn't hear anything. I didn't
either. And I really tried to listen to it, and I couldn't hear it myself. Even when I told my mind to try and listen for it, I couldn't. Is that something that could come into play in this hearing, that was actually allowed in front of the jury?
I mean, again, I don't know much about the pretrial rulings, but yes, it should be. I mean, that's crazily damaging stuff to hear. If the prosecutor, again, puts into play what she thinks that she heard, that's not good. And if the defense lawyers did not file a motion in limine to prevent that from being said, then that goes toward their ineffective claim.
One other piece of evidence that stuck out that the defense's attorney talked about in their opening statements today were some of the internet searches that Todd Mullis apparently made leading up to this incident and Amy's death, where he was very angry about the infidelity that she had in their marriage, and something along the lines of saying, what happened to cheating people in ancient times. But then the defense today argued that this was in a house where there's preteens, they had kids around. And maybe the defense in the original trial didn't push back on the fact that there were all these different people around. How could that come into play? Is that something big enough that could actually make a difference in a hearing like this? That the argument was that maybe he didn't do it himself when he's denied making those searches.
Yeah, I think it could have some minor impact on the ineffective assistance of counsel claim if his trial lawyers did not bother to make those types of arguments that, hey, there's 3 different kids or how many ever other people had access to the computers, and they didn't get into that kind of nitty gritty. I mean, these Google searches are incredibly common nowadays for defense lawyers when they're in trial. And those are the kind of the go-to arguments, is who had access to the devices. And if the trial lawyers did not make those types of arguments during the trial, then it could go toward the ineffective assistance claim. I view it as kind of minor league stuff compared to the other things that they're talking about today. The expert witnesses that are apparently going to come in and say that this looks like an accident. That's the big league stuff. The other stuff related to the Google search is probably more minor league.
Because in speaking of some of the big league stuff, I mean, there was, this now infamous corn rake that has 4 prongs. There were 6 holes in Amy's back. How, if you were a defense attorney on this case, how can you argue against it being something that was taken out, then put back in, and say it was an accident when there's 4 prongs and 6?
Well, I mean, I've thought about that since I read about the case and watched one of the videos that one of your colleagues put together on it, Jesse. But I would think that one answer would be potentially that did she fall on it, reach back, I mean, it seems preposterous maybe, but reach back out while she's on the ground and then fall back on it. That could be something that is, you throw out there in an argument. But what's confusing about it is how would there be 6 prongs if you would think it'd be 4 or 8 if it was, unless it just magically hit 2 of the holes again. So I would have to know more about it and look at the photos. And these are the types of things where you win and lose cases, is by brainstorming with people in your firm that, hey, what could have happened? There's a thing called psychodrama that we utilize from time to time, where you kind of put yourself in the shoes of what might have happened. And then you can really magically come up with, whoa, okay, I can see what theoretically might have happened. It may seem a little bit far-fetched, but it's something. And, so that it's hard to answer that question about how you would explain it away. You'd want to work in conjunction with your expert witnesses, but also your team that you have working with you, trying to come up with a game plan that makes sense and passes the laugh test in front of a jury.
Yeah, the laugh test is really important. This will eventually be decided, at least this phase of it, of whether there's going to be a new trial. It'll come down to the judge. Just for you, as we've gone through the bullet points of what's happened since that day in 2018, and then now previewing 10 days of dozens of witnesses. I mean, how strong of a case does he have to potentially get a new trial, in your experience seeing these kind of PCR hearings and how they play out?
I think it really depends upon the strength of the expert witnesses for the defense. If they come in there and say, my gosh, this was, I've seen this before as an expert, here's an explanation for the way that it could have happened. And then you have to link that up to the ineffective assistance of counsel claim. And so the stronger the witnesses are for the defense, the expert witnesses especially, and I don't know what other type of fact witnesses they have out there, but the stronger those witnesses are, then the more likely it is that the judge might say, I do think that these lawyers dropped the ball on this big time. And it's helpful, again, that the lawyers are cooperating and kind of owning what they've done or didn't do that they should have done.
For 40 witnesses, I mean, that's a lot. Sometimes there's too many witnesses in cases like this, where it's just hard for a judge, even a judge, like not just a jury, but a judge, to actually remember the key points of it. Yeah.
Oh yeah, definitely. I mean, those are decisions that trial lawyers have to make every day. Am I being too redundant? Is this too complicated? And I always tell the lawyers in my firm, find the most simple explanation that's easy to understand, but the most powerful. So if the most powerful argument requires 8 witnesses to kind of establish why it's powerful, but the second place argument is a one witness, you only need one witness to get that explanation out, then maybe that's the lead is the one witness. You hope that a judge has got the ability to write down information, but you're right. You're totally right, Chris. Judges, they're human beings and they get distracted. They've got other things going on in their courtroom. They're getting things on their computers while the hearing's going on about somebody requesting a continuance, and they may miss important moments in time. So you want to try to make it as simple as possible if you're able to, but if you need 40 witnesses, because this is going to be your last hurrah, so you better bring the goods would be another way to view it. And if it takes 40 witnesses, it takes 40 witnesses, and you just better have a really terrific summation, a final argument at the end to highlight those important points.
Yeah, and to your point, I mean, it really, all of this, as we preview the next couple of days, it comes down to the quality of those witnesses, and maybe 40 is what it takes. I mean, certainly it's a fascinating story to play out, has been for many years now. Andrew Baldwin, criminal defense attorney, thanks for joining us. We appreciate it.
Thank you, Chris. Appreciate it.
This is just the start of what is expected to be a 10-day hearing where roughly 40 witnesses are expected to be called to testify. Then it will be up to a judge to determine whether Todd Mullis could get a new trial. For On the Case, presented by Law and Crime, I'm Chris Stewart. We'll see you next time.